2, 1.
Доброго дня.
Good morning, colleagues. We are starting our meeting. The broadcast is also on.
У засіданні беруть участь члени громадської ради
Members of the Public Council of International Experts are taking part. Robert Hendrik Rasser, Norman As remotely, Mary Battler remotely, Joyce Lott Thompson is also remotely today, Gabriela Jodkaita, and Jane J. O'Sullivan. Members of the HKCJ Михайло Богоніс, Ярослав Дух, Роман Катасюк, Надія Кобецька, Олег Колюш, Ігор Кушнір, Руслан Мельник, Олексій Омелян, Андрій Пасічник, Руслан Сидорович, Сергій Чумак, Галина Шевчук, and others. I'm the chair. Andrii Pasechnik is also present. Secretary of the Commission, Natalia Vlasenko, is also present. Colleagues, but before announcement of the agenda, I would like to point out that today we are commemorating the Day of the Heroes of the Heavenly Hundreds. These are people who have given their life for the sake of countries, so I suggest to have a minute of silence.
Дякую.
Thank you.
Оголошую перелік питань про
I am
відповідність
announcing the agenda on compliance of candidates for the positions and judges of the Anti-Corruption Court with the criteria set out by Part 4 of Article 8 of the Law of Ukraine on the Anti-Corruption Court. Candidates: Dudikov Andrii Volodymyrovych, Shtifonov Pavlo Sergeyevich, Antipенко Viktor Pavlovich, Dudchenko Alexander Yuryevich. No other suggestions? Please vote. Who is in favor of this agenda?
одноголосно.
Unanimously.
Дякую. Перелік питань затверджено.
Thank you.
Отже,
The agenda has been adopted. So let's move on to the consideration of the first candidate.
питання, відповідно, прошу запросити до
Accordingly, please invite into the room candidate Dudikov Andrii Volodymyrovych.
Доброго дня.
Good morning.
Розглядається питання щодо відповідності кандидата на
We
посаду.
are considering the issue of compliance of candidate for the position of the judge of the Anti-Corruption Court, Dudikov Andrii Volodymyrovych, with the criteria set out by Part 4, Article 8 of the Law in Ukraine of the Anti-Corruption Court. Ukraine. We have members of the PCE present with us.
Джесіка Лott Thompson дистанційно. Члени Вищої кваліфікаційної
Members of the HKCJ of Ukraine. Михайло Богоніс, Людмила Волкова, Віталій Гацелюк, Ярослав Дух, Роман Кадасюк, Надія Кобецька, Олег Колюш, Ігор Кушнір, Руслан Мельник, Олексій Омелян, Андрій Пасічник, Роман Сабадаш, Сергій Чумак, and Галина Шевчук. You have the right to request recusal, to submit motions upon the permission of the chair to express your objections and challenge decisions of the commissions in instances set out by the law. Do you have recusal requests? Thank you. The co-rapporteur on this matter is Gazelyuk. Please.
Повторюсь, обом Андрієм Володимировичем за нашим словом. Шановні колеги, як ви знаєте,
So, dear colleagues, as you know, the competition has been announced. I will not mention all the circumstances regarding its conduct because all of you know all of that. I will start at once about the candidate. Dudikov Andrii Volodymyrovych is a judge of Tarnivsky District Court of Kryvyi Rih of Dnipropetrovsk region. In 2007, he graduated from National Law Academy of Yaroslav Mutrov, and he got the qualification of the lawyer. As far as we know, he does not have the academic title or degree. From 2007 to 2016, he worked at the position of the court clerk, consultant, assistant of the judge in the district court of Vinnytsia, in the Court of Appeal of Vinnytsia region, in Court of Appeal of Kiev, and High Specialized Court on Consideration of Civil and Criminal Cases. With the decree of the President of Ukraine dated August 1st of 2016, he was appointed to the position of the judge of Tarnivsky District Court of Kryvyi Rih of Dnipropetrovsk region for 5 years. And in the May of 2024, he was appointed to the position of the judge of this court indefinitely. During the period from February 6 of 2019 to February 6 of 2020, he was seconded to Trostyanetsky District Court of Vinnytsia region. We've sent respective requests to public authorities. We've got responses that determine some facts that we suggest to discuss today. Thank you. Thank you. Was everything accurate about the basic information? Yes, thank you. Everything was correct. At the same time, I would like to add I'm the participant of active hostilities and I have the award for the defense of Ukraine. Okay, thank you. Mr. Robert, the floor is yours.
Thank you, Mr. Chair. I please pass the floor to Gabriele, who is our rapporteur on your file.
So, hello, Mr. Andrii Volodymyrovych. It's nice to have you here, and we congratulate that you reached this level in this competition. And also, you received a lot of questions from our commission, and based on which are formulated main questions for the discussions today. But first of all, I would like to detail some information about your work experience. And as I see from your biography, you are working since 2015 until 2016 in the High Special Court of Ukraine for civil and criminal cases. And for a short period of time, you were court consultant here. In what sphere you gave consultations?
Consultations according to my professional activities. I worked in the higher specialized court, in particular in the civil specialization, and consultant in the court is there is an assistant and a consultant. We are selecting materials, we are helping during preparation for consideration of cases that the judge is considering.
And what type of cases now are you hearing in your Tarnivsky District Court?
Thank you for your question. Since the very first days when I was appointed to the position of the judge, regardless of the fact that I came as a civil specialization judge, the staff, colleagues, during the meeting of judges determined also that I would be an investigative judge. And for 5 years, and since I was appointed indefinitely, I have been performing duties of an investigative judge. Moreover, when I was seconded to Trostyanetsky District Court, I was also was the acting chair of head of the court because I was the only one there. So all categories of cases during my professional judicial life have been considered by me. Thank you.
And what experience do you have in solving corruption cases or similar cases?
Thank you for your question. Regarding that, I would like to inform that right now I do not have much experience. At the same time, I consider those cases that were received by the court. In particular, these were administrative proceedings related to corruption. Also, we had under Article 191, but I'm not concerned, I'm not afraid of developing, which is also confirmed by results. that I demonstrated during the selection. So I'm trying always to develop myself and to move forward. Not always, maybe it happens successfully, but I'm not afraid of any obstacles. And because life is like that, you also have to fight and you also have to improve yourself. Thank you.
Thank you. And now I would like to proceed to another part of questions related to the full access of to the register of court decisions. And there I would ask in the cases of short questions to be very concise. So in the answers to our questions, you confirmed that you used your full access to this register exclusively for the purpose related to professional activities as a judge. Is it correct?
Thank you for your question. Yes, indeed, I confirm that only for maintenance and development of my professional judicial duties, because I always, starting from being the assistant of the judge, I always try to follow the case law of courts of appeal, of cassation courts, of the Supreme Court, and full access helped me to find similar cases to my cases. Thank you.
And is it correct that no one else uses your login?
Thank you for your question. Regarding that matter, I would like to inform the following. Having looked through my dossier and I can inform the following. Previously, until 2022, there was access to the register, so there was login and password. After that, access for the full register is done with the help of the. I confirm that this signature is kept, as I've mentioned in my explanations, in the office of the judge. And I have not shared it with anyone. And the fact that there was prepared login and password, I can assume that I'm having looked through the dossier, I can assume that someone somehow, but once these changes were introduced regarding the full access, when we had to use the digital electronic signature, since then, no one has had access to that. Thank you.
Thank you. And according to the data provided to us by authorities, you made a lot of searches on Mr. Borsalo, who is ex-husband of your sister. And he has ongoing criminal cases, but nevertheless, when we ask you about the criminal proceedings, you were answering that I'm not aware of this particular criminal proceeding and have no relation with him. Is it correct information that you've given to us?
Thank you for your question. Yes, all the answers that I provided are confirmed by me. With respect to this, I would like to inform, as far as I know, that's not one criminal proceeding. There are many proceedings based on the information that I don't know. There was no one proceeding final. No. As far as I know, there are lots of them. Thank you.
And you do not know for what reason or for what specific criminal proceeding you were searching on him?
Thank you for your question. I would like to inform you that in the register, only data of individual are hidden. So information about legal entities are open. And that's the purpose of creating the register. So upon entering the name of the legal entity, anyone can open those documents that are available there, because only personal data are being redacted. Thank you for your question.
You also stated that your ex-wife represented Borsalo in commercial, civil, and criminal and administrative cases. Is this correct?
Thank you for your question regarding that. Yes. For some period of time, she was representing both him and the legal entity, because they have concluded an agreement, and she was representing them under all cases, because she, as an attorney, she is a professional in all spheres of law, and that's her work. That was her task. Thank you.
And do you made any searches upon the request of your ex-wife?
Thank you for your question. Regarding that, no, I did not make any searches upon her request. She never asked me to do that, because she knows how to use the register, and there was no need to do that. At the same time, I can inform you that I might assume that there was an event happening, because back then and now, in order to leave the system, it's not enough just to close the browser window. It's necessary to click on exit. I realized that later, and I might assume that since I was administering justice in Ternivsky court while preparing during the days off, because I arrived and understood that I had needed time to prepare for my cases. Maybe I did not notice, and did not exit the system. But that is the information that's available. That's not some secret. It's not hidden. So knowing this, it's not possible to use it somehow in the legal way. Thank you for your question.
Thank you. But once more, you made approximately, or under your logging activity, the searches was made on the Borsalo, his entity, probably his telephone number during the period 2017-2022, approximately 75 searches. So did you make these queries, and for what reason you were making them?
Yes, thank you for your question. As I have already indicated, and you have just confirmed it, starting 2025, when I started using electronic signature for any searches of any persons, there are no searches took place from my side of any persons, regarding any persons. And I can also inform you that I was interested in a case regarding a civil case. As a practice of the Supreme Court, the doctrine of the Supreme Court regarding that case that I considered, I was interested in. So I don't come in touch with him. I wasn't communicating with him. So for me, it was interesting to find out the position of a judge, how was the end of that case consideration, or maybe it was not completed yet. So I can explain the details of that case and the doctrine of the court regarding consideration of such case, because it's different, and it was contradictory to conclusions and rulings of the Supreme Court.
Thank you. Now, another part of the questions related to searches. We also noticed that you searched for your own telephone number, your own address, your own cars. How can you explain this? How were these searches connected to your judicial duties?
Thank you for your question. Yeah, as I have indicated already, and I would like to pay attention that search by my own name, as at the end of 2024, I renewed my carrying out of judicial duties, and as there is a martial law, so the data about judges, including myself, they are not all publicly open. As we have appeals regarding certain categories of cases, including civil cases and investigative cases where I participated. It doesn't go through the court of a first instance for me, so I don't know what cases that I have considered were challenged or not at the appellate courts or at the cassation courts. So I searched for such information as I always follow up, as I always follow the doctrine in cases that I consider, at the category of cases that I consider. So even when my decision or ruling is left unchanged and not overturned, I don't know about it. So the apparatus of court could inform me about situations if my ruling or my decision is changed or cancelled. And then, at the end of the year, I could use this opportunity indeed to reflect this information by judicial dossier. And then maybe once per week, sometimes more often, I use such search filters. I choose, for example, cassation or appeal, because when it's challenged, my decision is challenged, then the judge of an appellate court or a cassation court indicates also my name or my surname. And I see that, for example, appellate claim has been submitted, and what about my decision, whether it's left without changes or it's overturned or anything else. So I follow specifically the developments regarding my cases. As you say that I searched using my address, it's related to the reputational risk, because in order to provide relevant information, to respond, for example, searching for a place of residence, for example, if there are any claims regarding collection of debts, in order not to miss it. So that's regarding reputational risk, as I have mentioned, in order to be sure that there are no relevant proceedings regarding any kind of a debt or regarding my vehicle. And it's also known from the information that on January 2022, my vehicle was parked and a car accident happened. I called for police officers because the perpetrator, the accused person, has actually left the place, the scene of the car accident. And for a year, I didn't know at all what is the development of the case, where that person was brought to responsibility, where the car accident protocol was drafted by police officers or not. So it was used only by me, and I have not shared this information with anyone else. Thank you for your question. Did I answer completely?
Yes, but I understood. But do you think that such arrest already is for the personal intent, not for judicial duties? Reputational risks, more or less, they are just for personal interest, not for judicial duties.
Yes, thank you for your question. Yes, again, I would like to raise your attention that when amendments were made in 2025, I have not carried any such searches, and I have searched such information only for looking for relevant practice, doctrine, and to fulfill my professional duties. Thank you for your question.
Thank you. So, but also you made a lot of searches on other telephone numbers, other car numbers. And you answered that you do not know these numbers. So, does it mean that you search for random numbers in the register?
Thank you for your question. I can assume, regarding a phone number, that if I understand correctly, that it happened in 2017, 2018. Is it right?
22. 2017,
22. Окей. І, можливо, використовувалося
Maybe it was used to search for a phone number which was indicated in a certain protocol or in a certain file of proceeding in order to check whether this person's phone number indeed that their person phone number and this person was maybe brought to some kind of liability. For now, I have not been doing and I don't do any searches using my full access to the register because again, as I have said, I'm afraid of and and I'm afraid of using such a search. So I just use a Google search or checking my phone address book. So I indicated my phone number. Other phone numbers, I don't know. I don't know what it is and what these phone numbers are. Thank you for your question.
Thank you. Also, you conducted at least 30 searches in 2017, 18, and 21 for Zabiak Oleg Ivanovich. Why do you conducted or searched for this person? Because you indicated that you are not familiar with him.
Дякую за питання.
Thank you. Thank you for your question. Yes, I informed. And what I informed, it corresponds to the reality. When I made such a search at the open access database before submitting this information, I don't know what was it. I know, yeah, I see that it was indicated that it was Natsorny. No, I don't know. Thank you.
So overall, you searched approximately for 240 times. Do you consider this volume of searches consistent with stricter professional judicial needs?
Дякую за запитання.
Thank you for your question. Regarding this matter, I would like to inform you of the following. During administration of justice and consideration of specific certain cases, I can give you even an example, the last example, which cases I have considered lately. My rulings, the motions were submitted for searches under my proceedings. And in order to be sure, to be on the safe page, because for a certain period of time, I didn't administer justice, or in order to check whether indeed my conclusions were right while I considered the case, I looked for certain piece of information. You can just open details. You see that at that period of time, I considered, I had, and I looked for the practice of other judges. So search for practice of other judges, because I always apply practice of courts of the Kyiv region and my own region, the Dnipropetrovsk region. So when I administered justice in the Trostyanetsky court, I also analyzed practice of the Vinnytsia appellate court. And if I had any question regarding a search of property, so for example, if it's possible to carry out a search of property of a person on the wanted list, or for example, how to prove that that person is on the wanted list. So I searched, I checked and verified that indeed I see that my practice is, what I do is in line with practice of other courts, of other judges. So if a person is not on the wanted list, is not declared to be wanted, then there are no preconditions to have a search their property. So that's I checked what is the practice of other courts regarding consideration of this specific category of cases. Thank you for your question.
Thank you. Several more questions regarding your declarations. And in declarations of 2018, 19, and 20, you declared that you are using the car of your ex-wife bought in 2016, and but you do not indicate the value of this vehicle. How can you explain this? Because you participated in purchasing the car and in selling it.
Thank you for your question. Regarding this matter, I would like to explain the following. When I filled in a declaration, I clarified whether my ex-wife knew the value of that vehicle. Regarding my participation, I didn't participate in buying of this specific vehicle. That's why the value which corresponded to that was mentioned in the agreement was unknown to me. There was roughly known to me value, approximate value, as when there were last meetings between a seller and buyer, there were some negotiations took place to have a reduced price, like by $300, $400. I knew only the initial price when the announcement of selling of the vehicle was published, and the final price I don't remember. I didn't remember. And in order not to mislead you, and in order not to provide inaccurate information into my declaration, and as the NACP explanations tell us, if you use property and you don't know the real value as of the moment of the purchase, a person, the declarant, shall indicate the following: not known. And that's why I indicated it. So the vehicle I declared it in my declaration, but at the same time, I opted for this mark, not known.
Thank you. And regarding your place of living in 2018, because you have not declared housing near the place of work, so you do not answer to the question regarding some apartments in Trostianets village and Tulchin village. Do you know to whom these apartments belong?
Yes, thank you for your question. If you look at my questionnaire, my place of birth is actually Tulchin settlement. Tulchin settlement, that's the place where I spent all my childhood. I lived there till 1996, and my mom has an apartment located there. Thank you for your question.
And regarding Trostianets?
I also mentioned it that I used and I indicated specific location where I was residing for a certain number of days in Trostianets, and I gave you approximate calculation of days because lots of time has already passed. But again, according to the NACP explanations and other provisions of the law, I declared specifically the place in Vinnytsia at Konstantinovich Street, because according to our written questions and answers round, I indicated that it happened that at that period of time, my family was, separated and was just divided. And in 2018, it was 2018. So I lived in Kryvyi Rih till my secondment to the court in Trostianets village. So on the 5th of February or 6th of February at 6 a.m. in the morning, I started going to my main place of work in Trostianets, doing some simple math, calculating all the days. So my staff, which I moved from Kryvyi Rih, I moved specifically to Vinnytsia. Major part of the days at that year, I also was in Vinnytsia and resided in Vinnytsia. And I also informed you, I sent you that on 28th of December, starting 28th of December, I was on my annual leave, and as of 31st of December of the relevant year, I was at that very address. And that's why I indicated specifically Vinnytsia city as that place.
Thank you, and I have no further questions at the moment.
Thank you, Gabrielle. Norman, Mary, Jessica, you have questions? No? No. John? Back to you, Mr. Chair.
Дякую. Пане Віталію.
Thank you. Andrii Volodymyrovych, there are a few questions to you from our side of the Commission, and in order to have some such interim wrapping up conclusions. As far as I understand, based on this interview and previous in files of yours, which we have analyzed, there are certain periods of time during your life, there are properties which you have declared, and there are also some properties which you used in certain locations, but there are also other properties which, because of your own perception and position, were not submitted in your declarations. Yes. Then second question. During all your professional life, were there any properties which you used free of charge? Thank you for your question. Free of charge usage was conditional, and I indicated it in my explanations. De facto, it was more a rent. It was like a rent. As I say, that property in Kryvyi Rih, which you indicated, not before it, not before, after that fact, those people didn't rent it out. So it was provided to me based on friendship relations. So it was not related to my tenure in office. Each person has some periods of time in their life when they just give their shelter to other people to support them. But I always compensated those money for utilities. Yes, sorry, just. So I compensated this money to maintain this property for utilities, for example, as the owner of the property shall pay utility bills even if they don't use it. And that's why those people had relevant property, but they didn't reside there. And again, I said it, based on such comrades' relations, so to say, they suggested it to me. I'm so grateful to them for it, because that period of time was challenging for me. There was such an opportunity from them. They didn't want to conclude written renting agreements, but at the same time analyzing property, real estate market, and what were the prices at that moment. So I compensated this money for usage, but that money for usage was not above the threshold indicated by legislation, which requires a declarant to declare it. So I paid it also out of my own pocket. So it was not compensated to me. So I didn't note down everything in detail. Thank you. Thank you. I just wanted to understand what's the situation, what was there, what's not, why it's not filled in your declaration. So de facto, you were actually using some kind of property because of the reasons that you mentioned. So that was a reason, that was usage of property with payment only for utility bills. So the question. So as far as I understand, so the question, I'm not going to give you the address, but it's in Shabani settlement. So it was purchased by your father. Then your ex-wife purchased the park slot in the same settlement. How it was used in that moment?
Щодо цього, всі, хто знають, сам те Чебани не таке велике населення. Якщо можна по суті. По суті, я не використовував, я дізнався про це
So I learned about it just approximately in 2021, maybe even in 2022. After the full-scale invasion, I stayed where I resided back then, and my ex-wife asked me to check, and my child also asked me about that, but I did not use it. Is it a coincidence that in that year the wife resided there, and then your dad gets this apartment? It's just a coincidence. Apparently, she lives at a different address. Did she use it? Did she use this property at this address? I use this property to 24B, the address is. So is this somewhere near? It's kind of same condominium, 24, 24A, 24B. So in 2024, you were Dudikov KV granted permission related to the citizenship, Spanish citizenship, and I can inform you the following. After the full-scale invasion, to my knowledge, the bigger part of her life, she stays beyond Ukraine. She works abroad, respectively, and I don't really know, because I was not informed of this. I'm not in the know, but I can assume that she works there, she has entrepreneurial activities there. So you are not in the know. No, I'm not. Just quick questions. 3 years training in the recent 3 years, but not in 2024. I was dismissed from the service in 2024, 2025. I attempted to be useful to my colleagues, but because of the workload, they have a lot of that was welcome. And you decided that because you are teaching at the national school, you can skip the update of your skills. No. Because the law says it, I knew that I'm supposed to do that, but because of the workload in my court, where the workload for 4 judges is given to just 1, I felt that I could be useful there. In 2025, Vinnytska conscription center was looking for the individual whose data resembles yours, and because of an administrative misdeed, violation, for some time I could continue my activities, and after getting familiarized with my dossier and saying that the conscription center doesn't say what exactly I violated, I can inform that I talked to my brother in arms, and they told me that they didn't bother about such cases. So you had military service, and was it a mistake on the part of the conscription center? Did you try to resolve it? It sounds strange. Yes, it does sound strange to me too. So you didn't do anything, you didn't turn to the conscription center, right? Is this right? Well, it may have been that some actions may have been taken on the part of my employer. So as I was involved in justice and then in the military, it may have been a misunderstanding. Some document may have been filed on mistake. Regarding searches in the register, when did you learn that searches were done on your behalf? Thank you for your question. So once I got that information, so you're saying that someone was doing searches on your behalf. Once I got the respective request, and we all know that in those digital times that we're living in, well, the question was, have you turned to the law enforcement saying that someone did searches on your behalf? Not yet. I was on a leave and I was getting ready for the interviews and I was taking questions. From Monday, I will be in office and I will be getting this clear. And I want to inform that we'll know that colleagues, I'm talking about the access. So the question was very simple. Currently, no. So in order to clarify the circumstances, with the help of law enforcement, you didn't do anything. Thank you. Then anti-corruption agency, difference between the declared property and the property in the register. The car, 400,000, and in the register, 50,000, and some other differences. So thank you for this question. After getting this inquiry, I prepared a response and submitted documents that justify the values. So the values stated are real and they are in line with the respective contracts. So I declared the value of the property that is truthful and real, and I also I submitted the screenshots from the website confirming the purchase and also the receipt that the seller received. And who were the parties to this deal? In 2024, back then, a purchase of vehicles, cars could be done. Who were the parties to the deal? Myself and the seller. Did you say the value in the contract? I didn't sign the contract. So I'm trying to explain that it was possible to make that deal through stock market. So as I'm saying, the value is stated and the sums declared is truthful and real. But still, I don't understand why the register contains different information, and I don't understand why you don't know about this if you are party to this deal. In order to get this property re-registered, the seller provided the contract that was served as the basis for this deal. I didn't sign it. So if you take a look at it, so you didn't know what kind of value gets to the register regarding the car. So regarding the car, this deal was done by my wife, and you didn't know about the value that got to the register. No, did she tell you about the real price or the one that got to register? About the real price. So you didn't know about the real value of the car in the register. No. From her explanations, there was a previous contract and the general sum that was transferred for the car, so it was stated in the declaration and screenshots were submitted by myself. And you're saying I submitted this and that, and 400,000 was given to the seller. And you said I did it, but now you're saying my wife did it. So it was my wife. I'm sorry. Civil society inquiries, a part of their inquiries were already discussed, Article 130, and this is a very spread problem of the judicial system in Ukraine. And there are a couple of situations where there are differences between submitting the case to the court and the closure of the case. And the time period is time frame between these 2 points is very long, protracted. And there are also situations when case stays for more than 100 days in court. How can you comment it? So I actually provided written explanations. We've read those, and could you please quote one? Thank you for this question. I would like to inform the following. As I prepared to respond to this question, I made a search in the Unified Register of Court Decisions, and I found more than 377 decrees related to Article 130. And the last case is unrelated. It was closed because of the absence of the corpus delicti. And less than 5% of cases considered by myself are the ones that suit the mentioned definition. So such superficial consideration cannot be applied to such cases. And we try to avoid superficial consideration whenever possible. Yes, of course. In all cases, I try to establish the truth, even sometimes violating the deadline. But I did it independently, and when the individual didn't have the witnesses or the law enforcement involved or the side of protection believes that the court cannot state things that were not stated by law enforcement. The police did not use video cameras as they prepared the materials, and it was impossible to review the videotaped materials. It was impossible to summon the police officers or the witnesses present. And in other cases, I demanded videotape materials from the police. For 3 to 4 times, I couldn't hold a session because of the lack of such videotaped materials. But whenever the situation changed, the police officers provided the videotaped, I could hold a session and consider the materials. Is it worth establishing the truth when you understand that establishing the truth will not end in anything good because of the statutory limitations? So, some reading the books, Sadhetsmansky by Ivan Bahrani, it's worth accusing 100 guilty ones than releasing one non-guilty, and I try to always respect rights and freedoms of individuals. Thank you for your question. And regarding the practical work, one question, if my understanding is correct, just one remark. In November 2023, my dad had died, and I was in a very unstable psycho-emotional state, and I actually wanted to stop my participation there. I remember that, but please take into account my psychological state during that time, as I prepare the practical task. Then
один кримінальний закон, а на момент розгляду справи в суді другий кримінальний закон, там змінилася диспозиція і санкція.
When disposition and sanction of the laws have changed since the time of the violation, by the time of the court session, and a lower sanction was applied. How could you explain that? It was a mistake of mine. I quoted Article 5 in my conclusion, and I considered it in its previous form. In one of your verdicts as punishment, you said that you deprived the guilty of the guilty from the right to be in the position for 2 years. So that was the court's collective decision. Then I will have a question. In your questionnaire that you submitted for the competition, you mentioned only the period of your being a judge as your professional work experience. Yes, indeed. In my opinion, I thought I needed to state only this experience because the previous experience did not entitle me to this position. Now, do you understand that you were mistaken? Yes, yes, of course. And could you tell us, please, when did you start working at Terniv Court? In 2016, after taking an oath on December 15, and the next day I started. Okay. And you stayed there until 2019.
19 року був відряджений і приступив 7-го. Я прибув 6.02, Тростянець видав наказ.
А ви були відряджені, ви подавали заяву, так?
Я багато подавав заяв, намагався, я ж кажу, знаєте, перевестися поближче до місця.
I tried to get transferred closer to where I live back then. As you can see from my dossier, wait a second. Until 2019, you lived in Kryvyi Rih, right? Yes, yes. But I tried. I'm saying that after appointment, but Vinnytsia region is not closer to the place here as it is. From Kryvyi Rih, where you used to live, you moved to Vinnytsia, to Trostyanetsky district of Vinnytsia region, as far as I understand, right? Yes, thank you for the question regarding that. 300 kilometers is upon right now it's 470 kilometers from Chibany to Vinnytsia, and by the way, where the city of Vinnytsia, where my parents lived, is from the place of my residence, it's 40 kilometers.
На 100 кілометрів від Тростянця до Чебанів ближче.
It's closer by 100 kilometers. So what was the motivation? What was the motivation to get seconded to Vinnytsia region? Because you said, because you said closer to the place of residence, even though as you lived in Kривий Ріг. That's not closer. Closer to what? Given that what you just told you about the geography. I'm telling you, maybe I'm a bit it's clear for me. That's why I'm answering in such a way that the other external observer would understand that.
До того моменту, як був призначений на посаду судді, проживав в Чабанах.
Before I was appointed to the position of judge, I lived in Chabani, and I still live there, but another address. Okay, clear. And now back to my question. What was the motivation? Be seconded. After appointment, having worked for some period of time, for 6 months, I tried to get transferred to Kyiv region, or to Zhashkiv. What was your motivation? Not your attempt. My oldest son with my ex-wife lived in Kyiv region. Right now I also live at the same address. So I believe that my place of residence, the place where I want to live, is Chabani, where I live right now.
Ви сказали, де ви проживаєте і де ваші близькі особи проживають, так і не сказали, яка мотивація. Можна зробити висновок, але я просто...
We can make a conclusion. I just want to make this conclusion instead of you. The motivation was to move to the previous place of residence and closer to the place of residence of your close person. Yes? Yes, until 2018 I had a family, the previous family that lived there. Okay, clear. Tell me, please. Did you take into account these circumstances or no, and how you can assess them now? You were appointed to Tarnivsky court. The workload in 2019, as of the moment of secondment of Tarnivsky court, was in year 9,119 cases, and the normative workload is 31,020.
Це зараз.
What? Sorry. That's.
Показники по
These are indicators.
Тернівському.
In Tarnivsky court. The time for consideration 31,000
годин. Вінницька область.
Vinnytsia region, Trostyanetsky court, where you got seconded, and we all know that what is the institute of secondment. First of all, it's used to strengthen those courts which have higher workload. The normative time is 4,500 hours. There you had 31,000 and 4,500 in the court where you came. So the difference is extremely significant. It's not clear for me what was the purpose of your, not what was the purpose, but rather whether you took into account these figures, these indicators, and whether you took into account the fact that you are leaving the court with higher workload, moving to a court with a much lower workload. So basically the institute of secondment did not work for the sake of the purpose for which it was created. Basically, it has to be applied. What was your attitude towards such circumstance? Thank you for your question. With respect to that, I would like to inform the following. In Trostyanets, there were no courts. Justice was not administered at all for over a year. No one wanted to go to that court to work there, as far as I understand, because no one expressed this desire besides me. Since in Kривий Ріг I did not have my own housing, and I was indicating that Tulchin is my native town. My mother has an apartment there. Yes, it's not inhabitable. Okay, clear. So your position and your explanation is that regardless of the fact that the workload was lower there, you still ensured citizens access to justice because there were no judges. I think we should check that, because according to the information that are available at the website of the Council of Judges, there are 4 staff positions and 2 actual filled-in positions of judges in this court. May I? May I comment on that? I also wanted, once my secondment ended, I wanted to extend it, but at the same time, back then, there was no high qualification commission, no members, and I again returned to Ternivsky court, and I left the court without judges. 6 months later, there were appointed 3 or 4 judges there. So even I resumed it for a year. I tried to cover all the scope because all the civil cases. Okay. All of these circumstances are clear. I'm just clarifying because according to information of the Council of Judges, they had 4 positions, 2 of which were held by judges. Actually, that's specified at the website. Maybe it was a mistaken information, but you're explaining that there was no one at all. Okay. And my last question is about your secondment to the National School of Judges. In your application, you stated that after expiration of my duties, upon my own desire, I was seconded to the National School of Judges of Ukraine. Which authorities expired? My powers expired the 5-year term. Yes. And in order to maintain my professional skills at the proper level, as of the moment of the expiration of his powers, you returned to Ternivsky court already. Yes. I worked until the 5th of February of 2020. Okay, understood. So, what was your motivation when you were secondment to the National School of Judges? To maintain my professional level at an appropriate level? Because I understood that my powers expired, I had to try to expand my knowledge. I took part in the development of respective trainings in order to be okay. And the motivation that you mentioned before regarding your secondment in order to be close to your close person, did they play a role here? Of course, yes, and it's playing the role. I'm not hiding that this is one of the factors. Yeah, but you are not naming it. Okay, I have no more questions. Colleagues? Mr. Robert, maybe you or your colleagues have questions.
Not me, Mr. Chair. Jessica, Mary, Norman, no, die site is done well, Mr. Chair.
Гаразд, дякую. Отже, всі
Okay, thank you. So all the questions have been asked, all the answers have been received. Ms. Andrii, now you have an opportunity to address the Commission, the PCIe, but please be concise after a minute. Thank you. First of all, I would like to thank you. Besides, I would like to point out that today Ukraine is commemorating the memory of the heroes of the Heavenly Hundred who gave up their life for the democratic values, in particular for human rights. So for me, today's interview has a double meaning. I would like to express my gratitude to everyone present here. I would like to express my gratitude to our international donors who, during a difficult period of time, are providing assistance to us. Also, I would like to thank members of the PCIe for assisting in implementing those ideas for which we are all fighting. And I would like to thank dear members of the HQCJ for an opportunity to take part, to see some of my strengths, some weak parts, to reach respective conclusions and to move on. Thank you, everyone. Thank you. Goodbye. Now I'm announcing the interview over and